In January, a controversial labor bill became law of the land in California. The legislation, known as AB 5, took aim at the gig economy and two major players in the state, Uber and Lyft.
AB 5 is a massive shot across the bow from the state of California, really a gut punch to the gig economy.
AB 5 mandates that companies must reclassify independent contractors who meet certain criteria as full-time employees, eligible for health benefits, minimum wage guarantees, workers' compensation, and a slew of other labor protections.
It preserves our current union jobs because I guarantee you, if the new normal is if I hire you over an app, you have no rights, every one of our jobs are at stake.
Wedbush senior analyst Daniel Ives says the new law complicates the already bumpy road to profitability for the rideshare companies. He estimates that AB 5 could equate to $500 million in incremental expenses to Uber and $100 million for Lyft.
There's a lot of challenges out there for a ride-sharing industry that's still in its infancy.
Uber and Lyft immediately challenged the new law in court. Danielle Lackey, chief legal counsel of workforce management firm Modus, says the two companies have argued that AB 5 doesn't apply to them because they're technology companies, not transportation ones. This classification would put them outside the scope of the law.
They have continued classifying their drivers as independent contractors since it passed.
In May, the state of California countered Uber and Lyft with their own lawsuit, arguing that the rideshare companies had violated employment provisions under AB 5. So far, the courts have agreed with the state. A judge issued a preliminary injunction in August, which ruled that the ride-hailing giants must classify drivers as full-time employees. The ruling gave the companies 10 days to comply.
If a court doesn't reconsider, then in California, it's hard to believe that we'll be able to switch our model to full-time employment quickly. So I think Uber will shut down for a while.
Under the threat of a service shutdown in the state, an emergency court order delayed the ruling from taking effect. But while the legal battle continues, Uber and Lyft have invested over $100 million on a ballot measure to overturn the law.
They're basically looking to the voters to override the California legislature.
Proposition 22 would define app-based drivers as independent contractors and not employees. It would also establish some labor and wage protection.
They're not saying just give us a pass. They're saying let's provide an alternative safety net rather than the full suite of benefits that comes with employee status and also some of the rigidity that comes with employee status.
But Ives says investors should be worried about other states copying California's legislation. Similar bills are already being considered in a host of other state legislatures, including New York and New Jersey. Even Democratic presidential nominee Joe Biden has voiced his support for federal legislation that would rein in the gig economy business model.
It's not just in California. California does it, then there's a Pandora's box. What happens in other states, cities, and countries? This is really a major moment for the industry.
Hey everyone, thanks so much for watching Investors Business Daily on YouTube. If you want to watch more videos, make sure you hit that subscribe button so you don't miss a thing.